Looks like we're ready to go. Good morning, everybody. Welcome to the First District Court of Appeals. We have several cases on our docket this morning, but only one that's to be argued. And before we turn to that case, Judge Hendon has a disclosure that she would like to make. Judge Hendon?
Gentlemen, I would like you to know, and certainly give you an opportunity to weigh in on it, that I was a member of the Blue Line Foundation board. Now, that Blue Line Foundation is not the FOP 69. It is, however, an offshoot of FOP 69. I resigned from that board. The board is basically they're tasked with raising money to build the new FOP hall. It has nothing at all whatsoever to do with the running of the FOP 69. Does that concern either of you?
No objection from the union.
Mr. Reese?
No objection, I think, from us either, Your Honor. I think the officers are comfortable. You can fairly preside over this matter.
Thank you.
All right. Thank you both. Thank you, Judge Hendon. The case that will be argued this morning is Rumer versus Queen City Lodge number 69. Mr. Reese, you will have 15 minutes to argue this morning. Would you like to reserve any of that 15 minutes?
I would, Your Honor. I'd like to reserve 6 minutes of that for rebuttal if I could.
All right, you may. And whenever you are ready, you may begin.
Good morning, Your Honors, and may it please the court. My name is Chris Wiest. I represent Lieutenant Remer, who's the Cincinnati police officer, and another 10 Cincinnati police officers who are the plaintiffs and below and the appellants in this matter. And I'd like to begin my argument this morning by pointing the court to the complaint and the causes of action, because this matter was decided on a motion to dismiss for subject matter. And so given the standard of review, I think it's important to start with the claims and the facts necessary to support them. This matter, the claims themselves sought a declaratory judgment regarding the FOP's constitution and an injunction to comply with it. And there was a second cause of action dealing with the Ohio Constitution, public policy for filing the lawsuit, and retaliation. None of those cited Chapter 4117 or the SERB issues within that chapter. And when we look at the complaint in this matter, whether it's paragraph 7, which is one of the facts necessary to support the claim with the Constitution and bylaws of the FOP, paragraph 28 dealing with the meeting, all the way through paragraph 41, it's all about the Constitution and bylaws of the FOP, Robert's Rules of Order.
But I guess my question is, like, if we were to adopt your rule, does it just kind of encourage clever pleading to get around that? And what are we to do with situations where a claim under the Constitution, for instance, has impact on what would otherwise be unfair labor claims?
Your Honor, I think that decision, those issues have already been decided by the Ohio Supreme Court, and that gets right into Franklin County Law Enforcement versus Fraternal Order of Police, Capital City Lodge number 9, where the Supreme Court of Ohio says, thus, and I'm quoting at 170 to 171 of that decision, thus, as a matter of jurisdiction, if a party asserts rights that are independent of RC Chapter 417, then the party's complaint may properly be heard in common pleas court. And so again, and we see other cases.
But they didn't, I mean, the Supreme Court in that case didn't really, that issue wasn't really before them. So has the court subsequently to that ever fleshed out that concept to give us more guidance on how we're supposed to interpret it?
Your Honor, when you look at that case and you look at the determination of that case, there was some discussion actually within that case about the FOP Constitution and bylaws in that case. And what the Ohio Supreme Court said was, we're not really taking that up here because they didn't even specifically cite any provision of the governing body's constitution that would give us jurisdiction to deal with it. And so as the court was further discussing it, it talked about, contractual rights, for instance, that may arise. And other cases have dealt with contractual rights. Again, this is what we're really dealing with the bylaws and the Constitution. It's a contract between the membership as a whole and the governing body. And so it's a contractual claim. And when you look at the claims and the relief in this case, it was a declaratory judgment and equitable relief to comply with the FOP Constitution. It wasn't an unfair labor practice claim. It wasn't, hey, you're not fairly representing us, and therefore, we are seeking grievances and back pay and everything else. No, it was simply comply with the governing body's constitution and bylaws, and it was an injunction. And so when you look at the scope of the relief and the claim at issue, the only conclusion is whether or not it's a contractual claim that arises separately from 4117. And here it clearly does. Your Honor, when we look again at the standard of review as well, I would say that the facts and the inferences to be drawn are in favor of the plaintiff. And so when you take all of that together and you look at what's going on in this case, when you look at Franklin County law enforcement, I think the only claim that you can, or the only conclusion that you can draw is indeed that this was properly in the common police court to simply require compliance with the FOP's constitution.
Mr. Weiss, let me ask you this. What about the retaliation claim? Doesn't that fall under the Ohio Revised Code? And wouldn't that be the exclusive subject matter jurisdiction of SERB?
Your Honor, we disagree with that. And again, there's some cases that suggest, for instance, that I think there was some discrimination cases that were cited in some other cases, and whether or not arbitration rulings, for instance, that may give rise to, in some cases, perhaps concurrent jurisdiction. But the claim here it was not a 4117 claim that was cited. Instead, it was simply a claim arising under the Ohio Constitution. And I guess
what is the nature of that claim? Because there's like 3 paragraphs and they have no detail in them. So I was a little confused as to like what is the nature of the constitutional claim.
Yes, Your Honor. The Ohio Constitution has an open rights provision within the courts, and that is Article 1, Section 16 of the Ohio Constitution. And there's case law that articulates that protects people from retaliation for seeking judicial relief. We didn't fully brief that because, again, we're not even here really on a motion to dismiss for failure to state a claim. We're here on, does the court have subject matter jurisdiction? And so it wasn't necessary to flush that out below. But there is case law that suggests that you cannot, no employer, no one can retaliate simply by seeking redress within the courts. That gives rise to a public policy Article 1, Section 16 claim. And that was the nature of this, simply to prevent the retaliation. And I guess, Your Honor, I suppose there are some instances where if you file a SERB charge, you're protected from retaliation for that. But that wasn't what happened here. Obviously, there was a SERB charge that ended up being filed because we were belt and suspendering this, although we never believed that this was appropriately before SERB, because we weren't really dealing with interactions between the union and the city or the collective bargaining rights. We were dealing with an internal union governance matter that did not even, I think this is also important. When you look at Chapter 4117, nowhere in the entire chapter would there be a cause of action to allow union members to vote on their legal representation, which was the underlying issue. That right only arose from the FOP's constitution and bylaws, not from 4117. And so, we never believed that there was a 4117 violation. And so frankly, we didn't plead it in drafting the complaint. We never thought that jurisdiction was appropriate before SERB. And I think SERB's handling of the matter and finding no probable cause, even though very clearly they had the same materials before them that the common police court did, was with a verified sworn complaint, which was that the bylaws weren't followed, Robert's rules weren't followed, and they found no probable cause to find a violation. We agree.
We can't even consider any of that, though, can we? It's not in our record.
I don't believe it is in the record, Your Honor. And I think to your point, I think all of that is relevant only in the sense that, the appellees have raised it in their brief, and we agree that it happened. And I suppose, through the acquiescence of the parties, those facts, I suppose in that sense could be before the court. But certainly we think the questions, the analysis is look at the complaint. Are they alleging issues outside of 4117? Here they clearly are. Therefore, subject matter jurisdiction is appropriate in the common police court.
Mr. Weiss, is your
Yes, Your Honor.
threshold issue the manner in which the votes were counted?
That's exactly right, Your Honor. And that issue, again, is solely dealing with the FOP's bylaws and constitution. Those say you look at Robert's rules. Robert's rules say you look at those voting and you count based off those voting. And that's the genesis of this entire complaint. We say that, that did not happen on the night in question. Obviously, those facts are counted as being true for purposes of the analysis here. And our contention is that claim is appropriately adjudicated in the common police court. We're not even there right now because this was tossed on a motion to dismiss for subject matter jurisdiction.
But you do acknowledge that the votes were counted pursuant to Robert's rules.
No, Your Honor, they were not. in fact, the majority voting, Robert's rule says you count those who participated in the vote to determine the majority. And here, that did not happen. Obviously, the complaint pleads that. The actual vote, I think, was 138 in favor, 114 opposed. And what the union did was to say, well, we're just going to kind of count everybody that signed in for the meeting, even though we ran the meeting long and all the third shift officers had to leave for work. And so they played with the denominator, if you will, to deprive these people of the right to vote, to deprive the line officers of the right to vote, and to deprive the majority of those casting votes of the outcome.
So is the remedy you're seeking just a redo of the vote?
That would be sufficient, Your Honor, or we suggested that the Roberts rules be complied with, and therefore that the vote be counted. And again, what the union wanted was simply district-wide voting. They weren't. This was not a vote to replace legal counsel. This was instead simply that the line officers in each of the districts within Cincinnati would get to cast a vote on the question, and the officers would get to determine for themselves their own fate. And obviously, the games were played, which led to this lawsuit. But all they're asking for, and all the membership really wanted, was the right for the officers themselves to make this decision.
Mr. Wiest, you are over your time, but you're over your time due to questions from the court. So you will still have 6 minutes remaining.
Thank you, Your Honor.
Mr. Gage, you have 15 minutes.
Thank you, Your Honor. May it please the court. My name is Jessup Gage with the law firm of Lazarus and Lewis. We represent Cincinnati FOP Lodge 69. I'll be referring to them as FOP during the course of my argument. I'm going to start by again acknowledging the appellant's primary claim here and argument. And I'll quote from their brief. This case seeks nothing more than enforcement of the applicable governing document of the defendant FOP, its constitution. Now, the appellants asked the Court of Common Pleas, and they now ask this court to determine that a union member's allegations that they were not fairly represented when their union didn't follow the proper voting procedures and that their votes weren't counted the proper way, that is an issue that is not within CERB's jurisdiction.
Well, I don't think that's a fair characterization. I think what they're saying is there were procedural requirements in the Constitution that were not complied with. And so we don't even get to the question that you just posed because there's a threshold issue of whether the Constitution was adhered to.
Well, let me turn to the statute there, because we also have in further articulating their argument, they've again from their brief on page 2, they point out that nowhere is 4117 mentioned or implicated, and again, they've argued that it's difficult to understand how internal FOP Constitution governance matters about the overriding of the executive board could, quote, arise from or depend on collective bargaining rights created by RC Chapter 4117. So the appellants have argued that there is no nexus between following the Constitution and 4117. I will point out to you that there is considerable provisions in the Ohio Revised Code which make it clear that CERB actually is responsible not only for monitoring constitutions, making sure that constitutions have the applicable or the appropriate provisions within them, and that they're followed. RC.
Wait, I want to make sure I understand. You're saying that it is CERB's job to ensure compliance with the union's constitution.
Correct.
And was that the position you took when the matter went before CERB?
Well, when it went before CERB, they investigated the factual allegations. CERB was considering the merits of the claim. There was not a jurisdictional dispute when we got to CERB. The union always agreed that CERB has jurisdiction to consider the argument that the appellants were making, the claim. When the appellants, the appellants then took their claim to CERB, then we were not disputing jurisdiction, whether CERB even had the jurisdiction to consider it. It was whether or not the union did in fact violate their constitution. And so if you look at CERB's decision when they dismissed the complaint, they accepted jurisdiction. They specifically noted that they have jurisdiction, they accept jurisdiction, and then they moved to the merits and said, we've investigated this claim. We've investigated the factual allegations made by the appellants, and we find that they're meritless, that there is no evidence to support this claim that the union violated its own constitution and did not properly count the votes at the union meeting.
Mr. Gage, we can't consider any of that in this appeal, can we?
I
We
understand.
have the record in front of us.
Sure.
Our only issue is whether or not the common pleas court had jurisdiction. And let me
Sure.
back you up for a minute and follow up on Judge Bergeron's point.
Mhm.
As to your statement that there are many cases that say that 4117 covers interpretations of the union's constitution. Give me your best cite for that proposition.
Absolutely. Well, first, if I may, Your Honor, I want to briefly note the statute itself. So 411701C defines which public employees can be in a union, and that would be these police officers. It gives them a right to be in a union. 411703 gives the employees the right to, also gives the employees the right to join and participate in the employee organization. 411706 identifies SERB as the entity that determines who the employee's representative will be. So it creates that relation, that SERB manages the relationship between the employees and their union. 411711B1 makes it an unfair labor practice for a union or its representatives to restrain employees in the exercise of their rights to participate in the union. So in other words, if a union prevents the employees from participating in that union, it is an unfair labor practice pursuant to 4117B1.
But we don't, there's no allegation of that here. The allegation is simply that the correct procedure wasn't followed for a vote. It's not that the union isn't adequately representing the officers with management. It's not that, give me your best case.
All right.
Let's go back to
I'll
that
move on,
question,
yeah.
because that's a very specific proposition of law that you stated.
Absolutely. And one last, I will say, I'm sorry, probably the most important is 411719A and C. That actually gives SERB specific jurisdiction to require constitutions and monitor constitutions, make sure that the appropriate provisions are in constitutions. Now, if we look to, first, I would like to, I believe that Franklin County Law Enforcement Association actually supports the union's position, but if you want my best arguments first, let me start with.
Here, maybe I didn't make myself clear. You said that there are several cases that hold that SERB has exclusive jurisdiction, and I'm paraphrasing, so correct me if I misheard you, that SERB has exclusive jurisdiction in disputes between a member and the union over the interpretation of the Constitution. Correct.
SERB themselves have issued numerous decisions, which we've cited. So I'll start with In Re Amalgamated Transit Union Local 2268. That's SERB number 208-007.
I'm sorry, court cases. Do you have any case where a court has held in Ohio the proposition of law that you mentioned? Because you said it so emphatically, and I want to make sure that I've got your best case law for that.
I see. I don't believe that there is a case that has specifically contemplated SERB's jurisdiction to consider a constitution. There have been numerous SERB has issued, again, as administrative court, they've issued numerous decisions saying we have jurisdiction and talked about their jurisdiction to consider these matters. I don't believe anyone has been as novel as the appellants in this case as to try to challenge that to a court of common pleas or a court of appeals to say, no, SERB actually doesn't have jurisdiction to consider those disputes.
All right,
So,
thank you.
When I was referring to case law, I was referring to SERB's case law. They have said several times that they have jurisdiction to consider these matters.
But what do you do? I mean, I know you're getting ready to talk about Franklin County Law Enforcement,
Yeah.
but that case admittedly didn't decide this specific issue, but it did seem
Correct.
to carve out the notion that if there was a contractual, a constitutional dispute between members, that would be within the Court of Common Pleas jurisdiction.
I don't read that in Franklin County Law Enforcement, but I will sort of go through what I think Franklin County Law Enforcement decision does say. I mean, I don't think it goes so far as to suggest that is even necessarily a possibility. What happened in Franklin County Law Enforcement Association is we were dealing with, they were dealing with a case where non-members of the union that were represented by the union. So in other words, they were in the bargaining unit, but they were not participating members in the union organization itself. The union entered into a settlement agreement with the employer after the contract had expired. So there's no longer a collective bargaining agreement in place. There was some legal disputes between the union and the employer regarding the employees, and they entered into a settlement agreement with the employer. The employees that were non-members then filed a TRO and a preliminary injunction in the Court of Common Pleas, and they brought 3 claims. And I think the distinction between these 3 claims is incredibly important to understanding what happened in this case. The first is that the first claim was that the union representing them, which was FOP Lodge 9, different than Lodge 69, by the way, had defeated the rights of employees to a fair vote at SERB by entering that partial settlement that resolved only certain issues that were pending. Second, that the resolution of the economic issues in the settlement violated RC 325.17. So they identified a separate statute that said, in the absence of anything at issue under 41.17, the union actually violated RC 325.17, a separate statute, because we have an independent right or independent cause of action under 325.17, and we can claim that if there is no 41.17 issues. And they said, which reserved to their employer the right to set compensation. The third claim, which is actually the one that is most similar to this case, is that they claim the FOP Lodge 9 acted, quote, in its own self-interest and against the best interests of the employees in not affording the employees the opportunity to read the settlement agreement before a proposed vote on it, thereby violating 41.17.19C4 and the FOP's own constitution. So here again, we have a claim that they are saying you violated your own constitution because we didn't get to vote properly on this matter before you actually move forward, union, as an organization. Now, after there was a motion to dismiss, they actually amended the claim and also added a declaratory relief to the validity of the partial settlement to their claim. Now, what the trial court dismissed it, claiming on subject matter grounds, right? Claiming that they did not have subject matter jurisdiction. The 10th District Court of Appeals reversed it, but they did not reverse on all 3 claims. They reversed it, holding that SERB could not determine the validity of the partial settlement as it related to 325.17, that separate statute. They said, you've identified in your second of your 3 claims an independent right under 325.17 if there is no contract, if there's no 41.17 issues, and SERB doesn't have the authority to dispense with that claim under 325.17. Then the case goes to the Ohio Supreme Court. And significantly, the Ohio Supreme Court not only did not even address the 3rd claim about the FOP's constitution, although they did mention it in dicta, that there was no significant analysis or applicability to this case regarding their decision on that 3rd claim under the FOP constitution. Even under the one claim that caused the 10th district to find that SERB did not have exclusive jurisdiction, even under that claim, the Supreme Court said, yes, SERB actually does have jurisdiction over this because what you are claiming is effectively something that is under 41.17, even though you've identified 325.17, a separate statute, as the basis for your claim. So it is incredibly important to understand that first, even the one piece of their claims where the 10th district found there was no jurisdiction, that that SERB did not have jurisdiction, that could go to the Court of Common Pleas, even on that claim, the Supreme Court said, nope, still SERB's exclusive jurisdiction. And nowhere does the Supreme Court talk about the fact that because there was an allegation that the FOP Lodge 9 violated its own constitution, that would somehow give jurisdiction to the Common Pleas Court and not SERB.
But I thought the problem there was that the union never, or the members never identified the specific constitutional provisions. And so the court said, hey, there's no basis for us to understand that this is an independent claim from 41.17.
My reading of the case is not that was the reason that they, did not even address that issue. They noted that, by the way, you also didn't even identify the provision of the Constitution. So even if we wanted to, we couldn't even, address that. But I don't think that the failure, and this is where I disagree with the appellant's argument, I don't believe that the failure to identify the particular Constitution provision in the complaint was what caused the Supreme Court to dispense with that third argument. In fact, it wasn't even the basis for the 10th District to find that CERB didn't have jurisdiction. The 10th District didn't even find that the Court of Common Pleas actually did have jurisdiction because of the constitutional claim. None of the courts, the trial court, the 10th District, nor the Supreme Court looked at the plaintiff's complaint in Franklin County law enforcement and said, you have a constitutional claim and that could go to the Court of Common Pleas and not CERB, but only if you would identify the specific provision. None of the courts said that. And so that is what I think the appellants have argued this court should read into that case, and it simply isn't there.
Mr. Gage, you're approaching your time, but I have another follow-up question, and the other panel members may as well. I want to go back to the original argument you were making, which is, and again, I'm paraphrasing, but that it is within the exclusive jurisdiction of CERB when there's a dispute between the union member and the union over the interpretation of the Constitution that governs the union. And you started by going to the statute, which I agree is the appropriate place to start.
Sure.
And it defines unfair labor practices. And I think you said that there were two specific provisions in 411711 that deemed it to be an unfair labor practice if the union didn't follow its own constitution.
Correct.
Help me find those.
Sure. It does not use the phrase Constitution, Your Honor. I think that may be, let me be clear about that. I apologize if I was
What
misleading.
word does it use? It doesn't
Sure.
use contract.
Yes,
It doesn't use,
it actually, so it says in 411711B1,
yeah.
It's
I'm
an
with you.
unfair
I've
labor
got it in
practice.
front of me.
sure. It's an unfair labor practice for a union or its representatives to restrain employees in the exercise of all other rights guaranteed by RC Chapter 4117. And in 4117.
Well, let me stop you there.
Sure.
Let's go through that. So how is the allegation here that the officers were restrained from exercising a right under 4111? What right were they restrained from exercising?
Sure.
How
The
were they
right-
restrained?
The
Allegedly.
right, yeah. So 417, the B1 section I just identified says that if there's any other provision in Chapter 4117 that gives an employee the right, if the union gets in the way of that right, that's an unfair labor practice. The right at issue here is 411703, which gives public employees the right to form, join, assist, or participate in any employee organization union of their choosing. So what CERB
But
has
that's
said,
not what they're alleging here, is it? They're not alleging they weren't allowed to participate in the union.
I believe
they're
that they were not fairly participated because their vote was not counted properly. That CERB has consistently said in a lot of their cases that that is how they've interpreted the statute, that if you are not giving your members an adequate opportunity to vote and to vote fairly and counting the votes properly, that would be a violation of their right to participate in your organization.
All right. And then you mentioned a second subsection of B. What is the second subsection you want to refer
Right.
us to?
Sure. 411711B6. It's an unfair labor practice for a union or its representatives to fail to fairly represent the public employees in the bargaining unit that they represent. So again, to the degree that the employees here are claiming that the vote was not conducted fairly, CERB has consistently accepted jurisdiction of those sorts of claims when it comes to voting and constitution application by saying you have an obligation to treat your people fairly. If you have a constitution that says this is how you count the votes and you don't follow that constitution, that would be a violation of your obligation to allow your members to fairly or to be fairly.
But I guess that the issue is this claim, at least that they have sketched out, could be cognizable either as a standalone contractual constitutional claim or the claim that you just identified, a failure to represent all parties, all members appropriately. And so the question is, if they have the option to go either path, if they decide to go down the constitutional path and they don't decide to go down the unfair labor practice path, is that sufficient to trigger the common police jurisdiction?
I don't think it is, because I don't believe that you can have overlapping jurisdiction when there's exclusive jurisdiction of CERB. There's a significant amount of case law that just generally says something that is within CERB's jurisdiction, it's exclusive. So either CERB has jurisdiction of the issue or it doesn't. I don't think they can, that they have, that the employees have an equal opportunity to bring the same issue before both the trial court or CERB, and they just get to pick their forum. I think it's either or. And so once it's determined that it is CERB's exclusive jurisdiction, the word exclusive is in that standard.
Thank you. We have taken you well over your time, but before we turn back to Mr. Wiest, any other questions of the panel for Mr. Gage?
You took care of mine. Thank you.
All right. Thank you, Mr. Gage. Mr. Wiest,
you.
you have 6 minutes remaining.
Thank you, Your Honor. I want to begin with this notion that somehow every single vote gives rise to a CERB claim, because that just is not true. It depends on what the vote is. If it's a vote to recognize, for instance, a bargaining unit, certainly that gives rise to a CERB claim. But here the vote was simply to exercise a right under the Constitution. And I want to turn this court's attention to Franklin County Law Enforcement Association versus FOP at 171 and 172, because there the court noted that, and I'm looking at the discussion where the court's talking about plaintiffs also attempted to and I'm quoting from the Supreme Court, also attempted to justify their claim by reliance on the FOP Constitution. And then in response, the Ohio Supreme Court says, although union members can have common law rights that exist independently of RC Chapter 4117, we note that the plaintiffs did not specify the FOP constitutional provision that was allegedly violated. It appears that they referenced the FOP Constitution only to the extent that they contended RC 4117-19C4 imposed a duty on the FOP to provide in its constitution for the right of individual members to participate in the affairs of the organization. In other words, as pleaded, plaintiffs' claim under the FOP Constitution was inextricably intertwined with rights purportedly created and imposed by RC Chapter 4117. Your Honors, with due respect, that entire discussion is unnecessary if, in fact, you do not have an independent right to bring an action in the Common Pleas Court to enforce FOP constitutional rights. And I know the
Supreme Court saying that all you have to do to get around that is just identify the constitutional provision. Is that all that it takes?
Your Honor, that is certainly one reading I think that you could draw from that, but I have another reading that equally, would stand in my client's favor, which is that if you look at the underlying right that's being created by the constitutional claim, if it's not inextricably intertwined with 4117, and here it's not. I mean, what I heard a lot of was, it's somehow implied, or there's this implied right to vote. And I will tell you, Your Honor, with all due respect, there is not a single right that is anywhere in 417 to vote on legal representation, which was the vote here. So either way, I think on how you skin that, there we end. But I think there's another passage of the same case that I think is also relevant that I would turn the court's attention to. And that's the discussion that starts at page 172 of that decision, where the Supreme Court observes plaintiffs belatedly raised during oral argument the purported infringement of their First Amendment rights. Because constitutional rights exist independently of 417, such claims may be raised in Common Pleas Court, even though they may touch on collective bargaining relationships between employer, employee, and union. So again, I'm back to this, you got to look at the claims. And if you're alleging, as we did with the retaliation claim, a constitutional claim, that exists independently. If you're alleging, as we did here, a violation of the Constitution, that exists independently. And I think there's a couple other cases where the Ohio Supreme Court has reemphasized that. The State XREL Ohio Civ Serve Employees Association versus State, it was a 2016 decision by the Ohio Supreme Court. And at 329 of that decision, they said the principles announced the Franklin County Law Enforcement Association are not so broad as to place all claims that touch on RC Chapter 417 within CERB's exclusive jurisdiction. Thus, quote, we expressly acknowledged in that case that a plaintiff may raise in the Common Pleas Court rights which exist independently of RC Chapter 417, quote, even though they may touch on the collective bargaining relationships. And so again, you have to look at the claim, you have to look at how it arises.
And I guess, are you suggesting that if we were to find that there is a independent constitutional claim, but if it is inextricably intertwined with something under CERB's jurisdiction, what do we do with that?
Your Honor, I think that those facts are not present here, because here we don't deal with.
I know, but what if that was our conclusion?
if it's inextricably intertwined, I think that presents an open issue, because I don't know that was clearly delineated under Franklin County law enforcement, and I think that may be closer to a line that may remain an open question, where you have a tug and a pull between 4117 and a contractual right that isn't inextricably intertwined. And I think if it arises from 4117, perhaps I don't know that the Ohio Supreme Court has sort of touched on how to deal with that tug and pull. Obviously, that's not what we contend is the case here. We're not dealing with voting on representatives with the city, voting on a union contract, and sort of the more sort of core 4017 issues. We're dealing here with an internal governance matter that has nothing to do with sort of the interaction with the city of Cincinnati. And I think when you look at Franklin County law enforcement, when you look at the Ohio Civil Service Employees Association versus state in 2016, and then you look at the 2019 decision in City of Cleveland versus Russo, where again, the Ohio Supreme Court tells this court what the test is. The quote, and this is at 453 of that decision, quote, "The dispositive test remains whether the claims arise from or depend on collective bargaining rights created by RC Chapter 417. And in this case, with all due respect, there is no right that we found within 4017 would have given these union members the right under 4017 to say that they get to vote on their legal representation, or that they get to go and enforce it to a district-wide vote. That right rose solely as an operation, an application of their own internal governing documents. And I think that's where—
But couldn't an argument be made that that's inextricably linked with the representation in bargaining with the city? Who the lawyer is does go, at least in the broadest sense, to the adequacy of the representation.
Your Honor, I would disagree for this reason. There is no explicit right for union members to conduct that vote under 4017. There are other rights that union members have an absolute right to under 4117. For instance, the right to vote on who the actual union is that's going to represent the police officers, for instance. The police officers have an absolute right under 4117 to vote on that. Police officers have an absolute right under 4117 to vote on collective bargaining agreements, but they have no explicit right under 4117 to vote on this issue. And I think because of that, it cannot be said that this arises solely or is inextricably intertwined under RC Chapter 417. The only right at issue arises because of their internal constitution, which is a contractual right at its core. And when you look at the Franklin County Association case, I think the discussion about, quote, union members can have common law contractual rights that exist independently of RC Chapter 417, that discussion would have been wholly unnecessary in response to someone saying, well, wait a minute, it violates our Constitution. But that's not what the Ohio Supreme Court said. Instead, they said, yes, those rights exist, but here you didn't specify what the provision was. And so, of course, you can't have a breach of contract claim without actually setting forth what the contract is to get to the other, aspects of that claim, for instance, a breach. And so I think that's what that case turned on. Here, obviously, we have explicit provisions that we've alleged and that we've alleged were violated. And so we believe that the Common Pleas Court erred and that subject matter jurisdiction of these claims were properly brought before the Common Pleas Court.
You are at your time, but I'm sorry, I do have one follow-up question after hearing one of your arguments. The Constitution does provide for a right, as you said, to vote on who will represent the officers, what union they're going to belong to. So there are some issues involving the interpretation of the Constitution that wouldn't give the Common Pleas Court any jurisdiction, right? I mean, if here there was there wasn't a proper vote on who was going to represent the officers, you couldn't bring that in Common Pleas Court because that's governed by 4117.
Well, Your Honor, I want to be clear about what we're talking about. When you're talking about, you're not talking about a FOP Constitution claim in that instance, because what you're talking about is which entity is going to represent the union, whether it's going to be, in this case, Lodge 69, or sometimes you get into these competing, lodge questions. And in that case, it's not arising from the union's constitution itself. It's actually a right that's solely arising under 417, the right of the entire police membership to vote on their collective bargaining representative. You know, Lodge 69 versus, let's say, Lodge 40 or something. You know, if there's a competing lodge, those issues come up and there's cases about them. And in fact, that's what Franklin County law enforcement was fundamentally about, was who was going to be the collective bargaining agent, not, you know, is there an internal procedure that was violated, which is the question in this case.
All right, thank you.
Thank you, Your Honor.
Any other questions from the panel? No. Thank you both for your arguments this morning. We will take this case under submission and we will give you a timely written opinion.
Your Honors.
Thank you very much, Your Honors.
You're welcome. Thank you both. This will conclude the First District Court of Appeals argument for this morning. Thanks, everybody.